The bigger your challenges, the greater is your opportunity to success. Myself, Japji, student organizer of today's national webinar, extends a very warm and hearty welcome to all the dignitaries present here. COVID-19, in which students of our department participated enthusiastically and were highly appreciated. Webinar extends a very warm and hearty welcome to all the dignitaries present here. We, the students of Government Mahindra College, extends a very warm and hearty welcome to our principal ma'am, Dr. Simrat Kaur. We are lucky to have her as our principal, as she has given us various opportunities to organize online activities. It is with her blessing that we are able to organize our first national level webinar. Last week, our college organized a webinar on legal aspects of COVID-19, in which students of our department participated enthusiastically and were highly appreciated by the guest of honors. I also welcome Dr. Joginder Paul, HOD of Department of Law, for all his guidance during this webinar. My special welcome and regards to Teacher in Charge Dr. Sanjeev Mehta for his inspiration and valuable guidance during organizing this national level webinar. My warm regards to all the faculty members of Department of Law for all their moral support. It's a matter of great honor to introduce the keynote speaker of today's national seminar, who is well known in society. He's a renowned personality, Assistant Professor Jagteshwar Singh Sohi from Nalsar University of Law. He has successfully completed his graduation from the most prestigious college, that is, Army Institute of Law, and also he has double LLM. First from Nalsar University of Law and second from a renowned university in Toronto, Canada. He has attended various conferences, national and international level, and is a source of great inspiration for all of us. Now, I would like to request our professor, our guide, Dr. Sanjeev Mehta, to please come forward and welcome our most dignified, honorable keynote speaker of today's session, Assistant Professor Jagteshwar Singh Sohi.
A very good afternoon to all. I welcome our worthy speaker of today's webinar, Professor Jagteshwar Singh Sohi. I also welcome our principal ma'am, Dr. Simrat Kaur ji, our HOD, Dr. Joginder Pal sir, faculty member of different institutions, member of legal fraternity, my worthy colleagues and dear students. As we all knew that the Department of Law, Government Mahindra College is organizing today's national webinar. Resource person for today is Professor Jagteshwar Singh Sohi from Nalsar University of Law, Hyderabad. I feel privileged in giving welcome speech on behalf of the Law Department and Government Mahindra College. I conveyed my heartily welcome to our worthy speaker, Professor Jagteshwar Singh Sohi. Welcome, sir. Now, I immensely pleased to introduce our speaker, Jagteshwar sir. He completed his law degree in 2009 from the Army Institute of Law, Mohali. He first came to Nalsar for his master's degree, which he completed in 2013. Subsequently, he joined as an assistant professor there. He pursued a second LLM at Osgoode Hall, York University, Toronto. He completed it in 2018. His research interests lie within the field of environmental law and constitutional law, particularly in environmental and social justice. Now, I hope that ensuing session would be very meaningful and envisioning for our listeners. I again convey my gratitude to him for sparing time for us and gracing this occasion. Thank you, sir. Now, I request Mr. Jagteshwar to please come and deliver his lecture. Jagteshwar, sir.
The topic of my presentation is environmental justice, the power of public discourses or public opinions in judicial decision making. Before I begin the presentation, let me tell you how I'll be talking about this idea. I'll be talking this through the story of Niyamgiri. Now, two words are important in that. One, the word story, and why do I use it? So normally, when we as law students, law scholars talk about something, we generally work through statutes and case law. I believe that sometimes working with only those two causes us to miss out on the larger picture. We lose out a lot of information that goes out of focus in our very exacting way of looking at the system. So I tend to use the word story and I tend to rely on sources more than merely legal sources. So my research is informed, especially in this case, through in large parts newspaper reports, which were obviously then backed by legal documents, both case laws as well as statutes, and also reports by specific committees set up by the state to look at Niyamgiri. This brings me to the second word, Niyamgiri. Why Niyamgiri? And first and foremost, what is Niyamgiri? Now, very few of you may know of this place. It's in Odisha. It's lies in both districts of Kalahandi and Rayagada in Odisha, which are considered two of the most backward districts in the country. So I am looking at something which happened in Niyamgiri to bring out to you how public opinion can shape judicial decision making in terms of environmental struggles for justice. And why is Niyamgiri important? Why should we look at Niyamgiri and say, okay, this is a good place to understand the idea of environmental struggles, environmental justice, judicial decision making, and public opinion? Now, if we want to really study Indian environmental law, then some stories, some happenings, some struggles are of immense importance. We cannot really begin to study Indian environmental law without knowing about CHIPCO from the 1970s. We cannot really go much further without Silent Valley from the late 70s, early 80s, or without talking about and learning about the Bhopal gas tragedy in the 1980s, or the Sardar Sarovar Dam, the Narmada Dam in the 1990s, leading into the 2000s. So these stories are of such great value, such great importance to Indian environmental law and its history and its making, that without really focusing on these, we cannot study environmental law. Similarly, in these long line of stories comes the stories from Niyamgiri. I'll be focusing on a specific part of the story from, say, the late mid 2000s to 2013, but that doesn't mean the story isn't larger. It, in fact, began in the late 1990s, and one can not honestly say that it has culminated as of now. But it is of great importance to Indian environmental justice struggles, the stories of Indian environmental justice. So, with that, having given you a background of what I am going to be talking about and why I use certain words, let me move into the story of Niyamgiri. Niyamgiri is inhabited by this scheduled tribe called the Dongriya Kond. Now, this is a PVTG, which basically means it's a particularly vulnerable tribal group, which is a system of sort of classifying tribal groups by the government of India based on their own internal, in comparison to other tribal groups, education, health, uh, markers of modern development. So when a tribe is classified as a PVTG, it basically means that this tribe, even in comparison to other tribal groups, is primitive. In fact, the term PVTG, the particularly vulnerable tribal groups, is a newer term. It used to be primitive tribal groups or PTGs at one point in time, not so far in the past. So it's this group with very little education, modern education, or no modern education largely. It's this group with no access to modern healthcare as we understand it. It's a group which is largely a hunter gatherer group living on the slopes of the Niyamgiri range. Right. So it's very important for you to understand who we are talking about and where they are. So in the state of Odisha, which is a backward state in the country, uh, within that state, we're talking about the districts of Rayagad and Kalahandi, which are backward districts within the state. In those districts, we're talking about this one mountain range, Niyamgiri, within which the Dongriya Kond live, a particularly vulnerable tribal group lives. So it's the story of this group that we are interested in. To give you a small instance of how backward this place is in comparison on modern markers, I use the term in the way we use it in terms of modern markers of development. Uh, Bus service first came to Niyamgiri in December 2015. That's how remote this place is. That's how forgotten this place is. That's how marginalized this place is. So it's the story of these people, Dongriya Kond from Niyamgiri, from Kalahandi and Raigad, from Odisha, that I am interested in sharing with you today. Before I go on to talk about the story, let me also give you a brief idea of what environmental justice means. It is a movement which began in the United States in the 1980s, and it was a movement which basically said that environmental burdens and costs are asymmetrically divided amongst various sections of the society. That generally the richer, the more affluent sections of society, in America, the whiter sections of society, are cleaner, do not have polluting industries. The level of care taken by the state vis-a-vis the environmental well-being of those people is very different from the more marginalized, from the more backward communities, or the communities of color in the United States. And this movement has now become a larger international global movement. Whereas in India, we understand environmental justice in form of about our agrarian populations, our tribal populations, and their relationships with costs and burdens. For example, if you look at Narmada, the Sardar Sarovar Dam, it was built in a far off corner of the country, largely inhabited by tribal, very agrarian groups. But the electricity and the benefits were to flow to the cities of the country. Right? So it's asymmetric sort of balance of environmental harms is what environmental justice wishes to talk about. Within this larger idea, we have this idea of environmentalism of the poor, which is an idea given by Ramchandra Guha and Madhav Gadgil and Joan Martinez Eliot, which I relied upon to talk about the story of Niyamgiri. Now, environmentalism of the poor basically says that society is largely divided into, for our specific conversation today, two groups. One are the omnivores, the groups which can and which do rely on large parts of this earth to satisfy their needs. Uh, you can think of large corporations as omnivores. Omnivore is also a term used for an organism, for an animal that eats both vegetarian and non-vegetarian food. So herbivores, carnivores, and omnivores are some people, organisms, animals which can eat everything, which can consume everything. So when they use the term omnivores within this idea of environmentalism of the poor, they are alluding to these large corporations which rely on great swaths of land to satisfy their needs, their energy and their consumption needs. In response or in opposition to these omnivores, they talk about ecosystem people. People who, according to the definition given by them, rely on one or contiguous ecosystems for all their needs. So, tribal populations, especially PBTG populations like the Dombria Cone, fall very well into this idea of the ecosystem people. So they say that all environmental movements or most environmental movements in the global south, in India, emanate from this change in use of natural resources, which bring about competing claims over natural resources. Now, competing claims in form of the older population, the tribal population, the agrarian population, which has been living off that natural resource since times immemorial, and this newer, larger MNC corporation coming in wanting to consume that specific resource. I'll give you the example from the Niyamgiri story to make this idea clearer to you. The Dongriakon tribe have been living in Niyamgiri since times immemorial. There's only 8,000 of them. They're largely hunter-gatherers. They have a sustainable relationship with their environment. But the same hill, the Niyamgiri range, became important for the Vedanta group, which is a multinational corporation headquartered in London, in England. Now, Vedanta wanted to mine bauxite and refine it into aluminium in the hills of Niyamgiri. So in 1997, they entered into an agreement with the state of Odisha to mine this resource, bauxite, and convert it into aluminium. So you see, it's the same resource, the Niyamgiri Hills, on which one tribal group has lived for centuries, but which now this multinational corporation, which is an outsider to this place, wants to come in and wants to consume that resource, tear open the hills and mine out bauxite from them. So there's competing claims over a resource is where the environmental movement, according to scholars like Guha and Gadgil, takes place. They say when these ecosystem people who have lived on a certain resource for so long feel threatened by this corporation, by this omnivore coming in, they stand up in resistance. And that resistance is what any environmental justice movement or any environmentalism of the poor movement is all about. So you can think of this in terms of the Sardar Sarovar, you can think of this in terms of any number of even ongoing struggles in the country. So a very good resource that you can sort of look at to try and understand what type of environmental justice struggles are ongoing in the country right now is ejatlas.org. So ejatlas.org is a very good website where you can go and look at these struggles, and you can look at these from country profile, and India features rather heavily on this website. So you can have a look over there to try and understand how this sort of plays out presently. So anyhow, now we get the concept is clear to us. We have a MNC group Vedanta coming in wanting to mine bauxite in the Niyamgiri Hills, which are inhabited by Dombria Cone. And obviously they will not want their existence to be threatened in this form where they'll be either asked to move away based on what sort of compensation agreements can be drawn up, and we'll come to those in due course. So this story, as I said, began in 1997. Vedanta had already entered into agreement with the state of Odisha, and they would be mining this resource. Around the same time, I think this, if I'm remembering correctly, the agreement was from April of 1997, and in June of 1997, the Supreme Court of India gave the judgment in this very important case called Samta versus State of AP. Samta is Samatha, just in case one wants to follow up on the case. It's a very important case, also from the perspective of constitutional law. So not only is it important in terms of environmental law, this is a very important case in terms of constitutional law. In Samta, the court was dealing with Schedule 5 areas, right? And these have gone into historical documents, they've gone into work by sociologists and anthropologists all the way from the 1850s. And they've looked at how land tenancy laws in the country have developed since as far back as 1830 to look at the effect of the loss of land on a tribal person. So to try and understand whether mining leases could be given to these large corporations in this manner. Samta was a case the Supreme Court was looking at around that time, and they gave the judgment in June of 97, middle of 97, after the agreement between state of Odisha and Vedanta had already taken place. So in this judgment, what the Supreme Court says is of interest. It says you can only have mining in a Schedule 5 area. And I'm sure if some of you've done constitutional law, you will know that Schedule 5 areas are areas where you have a tribal majority population. The Constitution gives them certain specific special protections. And part of those protections, according to Samta, was that mining in Schedule 5 areas can only be done by 3 ways. One, by an instrumentality of state, one by the state itself, two by an instrumentality of state, and three by a tribal person or a cooperative or a group of tribal people. Right? So in no way, Samta clearly says this, in no way can private investors come and mine in a Schedule 5 area. Now, as some of you would have already guessed, Niyamgiri is a Schedule 5 area, it's a tribal majority area. So obviously this judgment of Samta extended to that as well. So no longer could Vedanta mine in Niyamgiri under the lease agreement that they had entered into with the state of Odisha in early 97. So over the next 2 or 3 years, and this is another feature of environmentalism of the poor, that the state, the executive, the legislature, really tries very hard to help the private investor. And at many times at the expense of the ecosystem people. Because obviously those are marginalized people, those are invisibilized people who nobody knows about. None of you before today's session probably knew about the Dongriya Code or Niyamgiri. If somebody did, then maybe a small minority of you would know about this. I'm guessing that. So the state ends up helping the large corporations, the MNCs, for various reasons, and not always unlawful reasons. For various reasons, because state has its own understanding of development, which is largely a neocon, a neoliberal understanding of development. So in this case also, after the Samta case came about, the central government tried really hard to get this case overturned. They applied for a modification of the order. Supreme Court said nothing doing, we are not modifying this order. They applied for revision of the order, and the Supreme Court again said, we're happy with the order we have given, and Samta is the law of the land from today. Okay. And Samta exists even today. It has not been explicitly overruled. It still is the law of the land. But herein comes the example of the preferential treatment that the state gives to private investors at the expense of the ecosystem people. So not just that they went and used state resources to try and get the decision overturned, but what they did next was interesting. First, they thought that they'll just amend Schedule 5 of the Constitution and just be done with it, with respect to mining in Schedule 5 areas. But this was around the year 2000, 2000, and something very important was happening in the country at that time. The government of the day was creating tribal majority states. Chhattisgarh and Jharkhand were carved out of Madhya Pradesh and Bihar respectively. So the government couldn't politically give tribal state and take away the Samta judgment by amending Schedule 5. So politically that wouldn't have been great. So what they did instead was they they asked state governments to start entering into joint ventures. Now, I'll give you an example of the joint venture that happened in this case to try and explain what that means and how that goes against the Samta decision. So the joint venture was entered into by Vedanta and Odisha Mining Corporation. Now, Odisha Mining Corporation is an instrumentality of state, right? And what this joint venture basically states is that the mining in Niyamgiri will be done by Odisha Mining Corporation, the OMC. But every bit of resource that is mined by OMC will be given to Vedanta. Now try and think of this in terms of the spirit of the Samta decision. The Samta decision says private investors will not be allowed to mine in Schedule 5 areas. Right? The state would be, instrumentality of state would be. So what they have basically done is they've stayed true by entering into this joint venture. They've stayed true to the words of the Samta decision, but not the spirit of the Samta decision. The spirit is to prevent alienation of land, of tribal land. However, now because the state, the instrumentality of state, OMC comes in and starts mining or will start mining, that leads to alienation of land. The population will need to be displaced. Right? Land which those people have lived on for centuries, which they know intimately, will need to be taken away from them. And there are other anthropological materials available on the effect of displacement in such forms of tribal populations by the state. We've lost tribal groups in this country since the 1900s because they were displaced and they moved to places that they had no clue of how to live on. And so in this case, the spirit of the judgment is what we are looking at and saying, well, wasn't that violated? Anyhow, so OMC was to mine and the entire resource was to be given to Vedanta. So the private investor gets the resource that the private investor is interested in. So once this joint venture goes through, the investors then start applying for clearances which are required to be taken for such a project. So under India's environmental laws, I'm sure if you have studied those already, you will know this, and if you haven't, you will study these in due course. 3 different types of clearances are required in such a case. One is an environmental clearance, which is required under the environmental impact notification of, at that point, 1994, though now there's a draft of 2020 out in case any of you are interested. Or under the Environmental Protection Act largely, there's an environmental clearance which is required. This clearance is to be taken from the Ministry of Environment and Forests. And the project proponent, so Vedanta in this case, has to make the application. A second clearance is the forest clearance, which has to be taken under the Forest Conservation Act of 1980. And the application has to be moved by the state of Odisha in this case, to again the Ministry of Environment and Forests. A third clearance is to be taken from the Supreme Court of India. And this is part of the T.N. Godavarman judgments. I do not really have the bandwidth to go into what the T.N. Godavarman judgments are, why that case is important, and believe me, it is one of the most important cases in environmental jurisprudence in this country. What the problems in that case, in relation to that case, are. I can't really go into that today because I don't really have the time for that. However, in the further part of this lecture, I will share with you the problems of T.N. Thirumalapad Godavarman, the case in relation to this present matter at Niyamgiri. I will talk about that. But a third clearance is required under that from the Supreme Court of India. It's called a project clearance. Uh, so these clearances, the applications were moved by the project proponent, by the state in 2004. Now the interesting part, which becomes another example of preferential treatment by state to the private investors, to the multinational corporation, at expense of the Dombia Code in this case. Another example of that is that the application which was sent to the Ministry of Environment and Forest by Vedanta, the environmental clearance application, it said no forest land is involved in this project and only 58 hectares of land is to be sort of worked upon. The forest clearance application, which was sent in by the forest clearance application, which was sent in by the state of Odisha in this case, said something very different. It said that 660 hectares of land is involved and that there is forest land in this case, in this matter, in this project which is involved. So both these applications have come to the Ministry of Environment and Forests. If this ministry is to work diligently, then it should be able to compare the two applications for the same project at roughly the same time in 2004 and clearly see that one or the other is apparently wrong. And the project could have been declined up there and then by the Ministry of Environment and Forest under the Environmental Protection Act of 1986. There are ways in which they could have just raise an objection and decline to give clearance. Anyhow, what they did was A, fail to notice this discrepancy. B, they delinked the mining project from the aluminium refinery project. Now remember, Vedanta wants to do two things. One, it wishes to mine on the hilltops of Niyamgiri, and then it wants to move that raw material down to the foothills and set up an aluminium refinery. Now the forest was on the slope. So what the ministry does is it delinks the two projects and says we are giving clearance for the refinery, but not for the mining as of now. Now this is problematic because without the mining clearance, the refinery makes no sense in this far off remote corner of the country. What the ministry is doing is creating for itself a fait accompli situation, which basically means they're creating a situation where tomorrow they will say, oh, but now the refinery is there and so much money has gone into the refinery. Might as well now give the clearance for the mining. Right? That's a fait accompli situation. And that is what they are trying to create in this case over here. So they delink the projects and they give clearance for the refinery and the refinery construction starts happening. But another problem is that even before this clearance for the refinery construction was given, Vedanta was already constructing the refinery. Not only the refinery, they were also constructing the pillars on which the conveyor belt to the hilltop would be located. So, in a sense, they have violated guidelines under the Forest Conservation Act at this point. The state forest department in Orissa raises objection to this. It provides notice to Vedanta. It says, give us an explanation why this is happening. The Ministry of Environment and Forest is oblivious. They don't look at this. And they say, well, this project is clearly a project which we can delink and we'll give clearance for construction of the refinery. Now, this is another example of preferential treatment out here. So, what happens next is that when you, as a person, as a citizen of the country, are not being heard to by your elected government, the state government, the union government in this case, both of them involved in this case, you turn to the judiciary. Right. And so did the Dongriya court through a lawyer, Praful Samantara, who has given his life to this Niyamgiri struggle over the last almost 15 to 17 to 20 years. They raised an application with the CEC, the Central Impart Committee. The Central Impart Committee is a committee set up by the Supreme Court of India in one of the ongoing cases in front of it, with the Thirullapad case. And its ambit is anything within the forests of the country. Any person or persons aggrieved by any activity in relation to the forest of the country can move an application in front of the CEC, and the CEC will give its findings to the Supreme Court, and the Supreme Court will pass orders and so on and so forth. So the CEC sets up a committee which looks at the application, and they immediately find errors in how this project is moving forward in relation to the environmental impact notification, in relation to the Environmental Protection Act, in relation to the Forest Conservation Act, and they raise objections. And the CEC says to the Ministry of Environment and Forests that you are not to give the forest clearance till we have looked at this case in its detail. So CEC then sets up a body, a committee which looks into this case in great detail, and they raise all sorts of concerns. They raise concerns of legal violations. I've already talked to you about some of the laws which were being violated. FCA, the Forest Conservation Act, was being violated. Environmental impact notification. The environmental impact assessment itself was found to be faulty. The assessment was with respect to taking water from one river, whereas in actuality the water was being drawn from an entirely different place. So the assessment was wrong. There were question marks whether public consultation had really happened or it hadn't happened in this case. So legal violations aside, they also raised objections with respect to biodiversity. They raised objections with respect to the hydrogeological cycle of the Niyamgiri Hills. They said the bauxite, which is at the top of the hills, acts as a natural aquifer, which basically means it acts as a sponge. It takes in the rainwater, it stores it, and then this water comes out in form of springs from this mountain, which form some really important rivers in southern Odisha, northern Andhra, present-day Andhra. So they raised major objections, and they told the Supreme Court about this. Now, what does the Supreme Court do? It does not, and this is the interesting part. This is where the environmentalism of the poor theory comes into play very powerfully, even with respect to the judiciary. Because what does the theory state? The theory states that the state, and that means the executive, the legislature, and maybe even the judiciary, sort of preferentially aligns itself with the corporations, the omnivores, to the expense of the ecosystem people. So what does the Supreme Court do when it's given a report by a body created by itself, telling it of all these legal violations? it does not look at those legal violations. Now, we as law students and law academics would believe that the judiciary would look at that first and say, well, clearly there are violations of the law out here, so we cannot allow this project to continue. But that's not what they do in this case. Instead, what they do in this case is they set up, ask the Ministry of Environment and Forest to set up two committees. One committee is to look at the biodiversity angle and the loss of biodiversity if the mining is to begin. And second, they ask for a survey with respect to the hydrogeological cycle. Now, again, the very fact that they do this is an example of preferential treatment and is problematic. But then let's move on into what happens with these studies. So the study with respect to the hydrogeological cycle is given to CMPDI, which is um, the Management and Planning Institute at Ranchi, which is interestingly a wholly owned body, a wholly owned institute by Coal India. Now, Coal India itself has an interest in mining. So, why would you ask somebody who's interested in mining to do research on which could possibly lead to cancelling of a mining lease? Now, that by itself is questionable. The CMPDI comes up with a report which, if you read through it, and later bodies have said so, seem interesting is a word one would use. Because they say that if you are to mine on the Niyamgiri hill, it will not negatively affect the hydrogeological cycle. In fact, it will positively affect the hydrogeological cycle of the hill, the range, because mining will create more cracks in the range, allowing rainwater to seep into the ground. Interesting to say the least. And let me leave that at that. But the problem is the fact that why would you give it to CMPDI Ranchi? Why wouldn't you give it to a neutral institution to do this research? The second the research committee, which was to look at biodiversity, was given to the Wildlife Institute of India in Dehradun, the WII. Now, this body comes up with a report, and the first report they come up with uses the term irreversible damage. They say if this project is allowed to go through, there will be irreversible damage to really important biodiversity in the region. And the word irreversible is really important for lawyers, because lawyers know that wherever the word irreversible damages comes in, the precautionary principle applies. So when this report is initially given to the central government, the Ministry of Environment and Forest, they look at the term irreversible damage and they are like, that is not a good term to be used if this project is to go through. So they ask the WII that why don't you allow the state of Odisha to give you a presentation on the project? This presentation is given and the WII submits a second report in which they say if X crores of money is given as compensation, is routed as compensation, then this irreversible damage can be taken care of. Then a management plan can be created to take care of this problem with respect to the biodiversity in the region. Now, let me stop there and ask you a question. Something which is irreversible, a damage which cannot be reversed, how much amount of money will be able to reverse it? Because that is the meaning of irreversible. No matter how much money you spend, you cannot bring it back to the original position. Right? So a number of different really important people have called out this second report given by Wildlife Institute of India as the central government leaning on the institution to get a favorable report. Madhu Sareen says so. Similarly, one of the authors of this report actually has been quoted as saying that we live in the real world. One needs to understand this sort of thing happens all across the country. And I leave you to judge whether the second report was free and fair. Anyhow, so based on these two reports, the Supreme Court of India in 2007 then begins hearing in the Niyamgiri case to try and decide whether the project clearance has to be given or not, and whether the Ministry of Environment and Forest can give the forest clearance. Remember, the environmental clearance has already been given, the forest clearance is pending, and the project clearance is pending. So in 2007, they start hearing this case with respect to those two clearances. And this is where another example of preferential treatment will come through very clearly. So in this case, now this case is being heard under the name of T.N. Thirumala Path Godavar. Now this is a case which actually began in the early mid-90s, so 94, 95 is when Thirumala Path Godavar began. It's an ongoing case. It's a matter, I can't really go into the details of it, but it is a case under which the judiciary has acted as the administrator of forests. So it's taken over the executive's functions. So a lot of people have questioned the judiciary's actions with respect to separation of powers, a concept you would have studied in constitutional law or would study in constitutional law. So anyhow, in this case, the two parties are the state of Odisha, the union government, Vedanta on one side, and the amicus curiae on the other side. I will not go into who the amicus curiae in this case was or who the junior amicus in this case was, and that is important. And if you're interested, you should search up on this and find out who the junior amicus in this case was. Now, the importance of amicus out here is the fact that amicus is there means that the party is not being represented by a lawyer of their own. So Dongriya Kond in T.N. Thirumala Path Godavarman in Re Vedanta Alumina is not being represented by a lawyer of their own. They are being represented by an amicus, a friend of the court appointed by the court. Now this is very important because there's a 1998 a system which was created in 1998 by a conference of chief justices, which states that in case any judge has an interest, maybe a monetary interest, in the stake in either the stakeholders of a case or has any stake in a case, then he or she must openly declare so in court. And if either of the two parties objects, then that person, that judge, must recuse himself. Now, in this case, a soon-to-be Chief Justice of India, I will not again name who the person was, but if you want, you should read Anuj Bhuvania's book, Quoting the People, in which he speaks about this controversy. There's also an older interview given by Prashant Bhushan with respect to this specific controversy, which then led to him being charged with the contempt of court at that point. So I will not name anyone, but all I'll say is that a future Chief Justice of India, who was the second senior most judge in that case, was somebody who had a pecuniary interest in Sterlite. Now, Sterlite is a name you are hearing for the first time, so let me give you the background of Sterlite. Sterlite is part of the Vedanta group. So the larger umbrella group is Vedanta, and a subsidiary of it is Sterlite India. So this judge had an interest in Sterlite. So he or she had to declare this in open court, and he or she did do that. They declared it in open court. And now, if either of the two parties objected, then he or she must recuse himself, herself. Now, obviously, the union government, the state of Odisha, Vedanta are not going to object, because if there is any bias, it is in their favor. So they wouldn't object to this person being on the bench. But obviously, the Dongriya Code would want a recusal in this case. And their lawyer, who was present in the court in this matter, stood up 3 times and objected to the presence of the said judge on the bench. All 3 times he was told that if an objection was to be made, then the amicus will make the objection. Now, the amicus has an interest in being part of this large case, which is known as the Forest Case of India, because it is heard every week by the Supreme Court of India. You're present there, you're heard by the bench, you cultivate a relationship with the bench while being on the bar. And this amicus, the junior amicus, who has since gone on to become a judge of the Supreme Court of India, does not raise an objection with the person being on the bench. Is this problematic? I leave it to your better judgment. But Anuj Bhavania, who's a professor at the South Asian University in Delhi, in his book quoting the people, writes about this as being problematic. Anyhow, but let us believe none of this is problematic, that the judiciary is fair, it's independent, and will take its decision based on the legal matter in front of them, and will not be swayed by any personal interest. Let's assume that for now. So the hearings begin and they go through in this case, and the judgment is passed on 23rd of November 2007. So if any one of you is interested, it's a short judgment, it's hardly 4 or 5 pages that you need to read through. And it is very weak on law. There is no reference to the Samtha case, the precedent which stands in the way of the project. No reference at all. There is no reference to the 5th schedule of the Constitution. There is no reference to the PESA, the Panchayati Extension of Scheduled Areas Act. No reference at all. There is no reference to a legislation which will come into force within the next month. A very important legislation, the Forest Rights Act of 2006, which came into force on the 1st of January 2008. All of these legislations, in some form or the other, create special sort of situations with respect to tribal land or tribal people. None of this is referred to in this judgment passed on 23rd of November 2007. So this judgment is very poor on the law. But because obviously the court has to show itself to be taking a judicial decision, they have a minor reference to sustainable development. And anyone who's worked in environmental law for a while will tell you that whenever the court refers to sustainable development, it can be used to go either way, to allow a project, reject a project, depending on various factors. So sustainable development in that form isn't really any protection to the environment. It can be used in either case. So this judgment uses the term sustainable development as the cursory law that the court is relying upon. And what it does is it says it looks at the track record of Vedanta in other countries, and the track record isn't great with respect to environment or with respect to labor rights, labor laws. The track record of Vedanta is very bad. So the court looks at this track record in its judgment and says, look, we cannot allow Vedanta to go on with this project. Now, at this stage, you would be thinking that maybe the right decision from an environmental standpoint has been taken. The judiciary is standing up for the citizens, for the environment, and protecting our rights, the rights of the Dongriya Kund in this case, and the environment of Niyamgiri, the biodiversity at large. But it isn't. The judiciary says that we will invite Sterlite Industries India Limited to take forward this project instead of Vedanta. Now, where does Sterlite come from? Why is a private body being invited to come and take forward this project? Now, one of the only sort of connections that one can see is that one of the judges on the bench had a pecuniary interest in Sterlite Industries India Limited. Out of nowhere, when this company lands this major project, the share in the share market will spike, will jump, and somebody stands to gain a lot of money, a financial interest is at stake. So somehow Sterlite is asked to come forward and take this project on. Obviously, some restrictions, some conditions are laid down for it. And in 2008 August, they filed affidavits in front of the Supreme Court of India saying that yes, they agree to the conditions. And the Supreme Court of India passes a second judgment in the Niyamgiri case in 2008 August, stating that the order, the proposal from 2007 judgment is so ordered, and Sterlite can begin the project in a joint venture with OMC, the Odisha Mining Corporation. Another example of preferential treatment. So environmental justice struggles are these struggles where you have this preferential treatment to an affluent group, to this omnivore, which is an outsider to the resource that it is coming in and wants to use and consume for private interest, not national interest. It is very important for all of us to understand that though the state will tell us it's in national interest, the percentage of money that the state, that is we the people, make from these mining projects vis-a-vis the larger extraction is very little. And in case some of you wants to follow this up, there is great work by the Goa Foundation. It's a group which has been struggling against mining in the state of Goa and is asking for greater amounts of money, of profits to be shared with the state, with the people. Because as of now, those profits which are being shared are in the low single digits. So if 100% of the resource which we own, which the state holds in public trust, and these are all legal concepts which are law in India, if 100% of the resource is exploited, we the people get less than about 3 to 5%. The rest goes into the private players' hands. 95% of the profit. Way too large. Right? So anyhow, Sterlite in this form comes forward and they get this project. So now what do the Dongriya Kund do? What is the option left in front of them? Now they have been failed by the state government, which is supporting Vedanta since the beginning. They've been failed by the clearance given by the central government, the Ministry of Environment and Forest, which failed to look at the discrepancy between the two applications and certain other violations of the laws which have taken place. They've been failed by the judiciary and the apex court in this case, the Supreme Court. What do? So they begin a campaign of direct action. They begin by blockading the Niyamgiri hills so that the trucks of Vedanta, which are helping in the construction activities and the excavation activities, cannot get in and out. They are being held by local NGOs. One is a local group of only Dongriya Kund people called the Niyamgiri Suraksha Samiti, the NSS. So they are very active. They are being helped by Praful Samantara, who I referred to earlier, who's a lawyer who's been part of this project, part of this resistance for almost 20 years. They're also being helped in this case by Survival International, which is an international NGO which deals with mining projects in various different countries across the world. And they are doing these human chains, they are submitting memorandums to state governments. Locally, they are creating blockades, they are making demonstrations, there are padyatras across the Niyamgiri range, generating awareness amongst the people. There are Nukkad Nataks in Delhi, there is plays being done in Delhi, there are candlelight marches in Delhi. There are marches in London outside the Indian High Commission. So a lot of on-ground work, a lot of activist work is happening to now change the situation, to try and protect the Dongriya Kond's existence in this range on which they have lived since forever. Because one more thing is important in this case. The Niyamgiri Hills are very important for the Dongriya Kond from a cultural standpoint. They believe, and this is a tribal group which lives on the slopes of the Niyamgiri range, and they believe that their god, their ancestor, lives on the top of the hill. They refer to him as Niyam Raja, and they believe that all good in their lives comes from Niyam Raja. So there's this interview with one of the women in Dongriya Kond women, elderly women, which is published in the Hindu, the newspaper, in which she says, all I need, I get from this mountain range. Everything in my life, all fruits, vegetables, millets, water, I get from the range. I don't need anything from the outside world. So the only two things that the Dongriya Kond largely rely on the outside world, or at least she does, is kerosene and salt. Other than that, she says, I don't need anything from the outside world. This is my place, and my God lives on top of that place. How can I allow my God to be desecrated in this way? How can I allow you to come in and mine where my God lives? Right? So, this is another interesting part in the Niyamgiri story which one needs to focus on, because it is very quickly going to become a central part of the struggle. Now, till 2009, none of this has been of any great interest to the judiciary, to the state government, to the central government. No one's really looked at the Dongriya Kond. Even the reports by the CEC have focused on legal violations, focused on biodiversity, focused on hydrogeology, but not really on the people who are going to be affected. In 2009, a movie is released, a Hollywood movie is released across the world, and quickly goes on to become one of the greatest blockbusters the world has seen. Avatar. Now, I'm sure some of you have seen the movie, heard about the movie. Those of you who haven't, Avatar is a movie about this fictional tribal group which live in a forest and believe that their ancestor, their god, lives in a part of this forest. And under that main part of the forest where they believe that their god, their ancestor lives, their ancestors who died live, there's a mineral that this outside world is interested in. And this movie becomes a great success across the world. And people start writing about the Dongriya Kond. They say, aren't the Dongriya Kond the same as the Navi people of Avatar? They are a primitive, a particularly vulnerable tribal group, a hunter-gatherer group which has little to do with the outside world, who believe that their god lives in a place that the outside world, the state of Odisha, the Union Government of India, the the private investor wants to come and exploit. So suddenly, this forgotten story of the Dongriya Kund becomes a central focus of the world. So, in the march outside the Indian High Commission in London, Survival International ropes in the actors, the directors of the movie to come and sort of be a part of the procession. And suddenly, this is becoming big news. And this is why I use this case as an example of public discourse and how that fashions judicial decision making or even decision making by the state. Till this point, in my research, I looked at news stories on Drogdiapo, news stories on Niyamgiri in 10 leading English language dailies in the country. So I started my research from 97 and looked up till 2013. How many stories were published in newspapers, in the 10 leading newspapers in this country in that period? Right? So the point was to try and see how much information was in the public domain, how much opinion was being formed or was being showcased in these news stories, because there's a lot of research on news stories, newspapers, and what they do. They create public opinion or do they reflect public opinion? There's two-way street. Right, so I was interested in trying to see how much public opinion they were driving or how much public opinion they were reflecting. So from 97 to 2007, when the first judgment comes out, when the judgment where Sterlite has given this project, when Dongriya Kund hardly ever referred to in this judgment, in the 10 leading dailies, total references were in the single digits. By the 2008 judgment, when the project is confirmed, around 20 odd newspaper stories have come out in a 10-year, 11-year period in 10 different papers. So you can basically say around 2 or 3 stories in every newspaper in 10 years. That is hardly going to be noticed by the common man. But between the release of Avatar in 2008-9 and it becoming a phenomenal success, and late 2009, when the Ministry of Environment and Forest refuses forest clearance in this case, in this period, around 250 different newspaper stories in those 10 dailies have come out. So within a 1-year period, 250 stories. That's roughly 25 stories per newspaper in just a year. Now suddenly Niyamgiri is becoming the central focus. So what does the central government do? It quickly takes away its support from this project. Now the central government in this case was the Congress government, the UPA government. And they were the government right from 2007 when the clearances, 2004-5 when the clearances were initially asked for, 2007 when the court gave the clearance, so the party which was out there in the court representing the union government. Now it was a Congress throughout. In 2009, 2010, they refused to give clearance when they themselves had given clearance beforehand, the environmental clearance, the provisional forest clearance, all were given by the same government, but they pulled back their support in 2010. Nonetheless, the state of Odisha is interested in the project because obviously this will drive in money into the states. They are interested in the project. So state government is with them, and Vedanta is going to file a case now, which comes up for hearing in 2013. And this forms two critical parts of my presentation. One, whether public opinion, public discourse shapes judicial decision making. That will be answered here. And two, how can these environmental justice movements gain success in face of previous failures at the hands of the state, all in forms of the executive, the legislature, the judiciary? How can they gain success? So activism, opinion shaping, opinion making, getting information out to larger populations is how they gain success in large parts. And yes, they can shape judicial decision making. Because now, if you look at the 2013 judgment, and I would honestly, if some of you are interested, I would recommend you to read the 2007 judgment from November and the 2013 judgment. You, in case you hadn't heard this lecture, you would be hard pressed to guess their judgments on the same matter. The 2013 judgment is a judgment which focuses on the Samtha case. The 2007 judgment does not even refer to it. The 2013 judgment focuses on the PESA, the Panchayati Extension of Scheduled Areas Act. The 2007 judgment does not even refer to the PESA. The 2013 judgment refers to the FRA and the need for consent from the tribal population under FRA. The 2007 judgment does not speak of the FRA. The 2013 judgment speaks of India's international law obligations under the UN DRIP, the United Nations Declaration on Rights of Indigenous Populations, Indigenous Peoples. 2013 judgment talks about the UN DRIP. The 2007 judgment does not even refer to it. Now answer me this. Why did the Supreme Court of India write two extremely different judgments on the same subject matter? The facts of the case have not changed. The legal violations have not changed. The laws of the land, the rights of the Domriya Code have not changed between 2007 and 2013. How come the judgment changes so dramatically? Between 2008, 9 and 2013, 900 odd newspaper articles had been published in 10 leading journals. That is 90 articles per newspaper over a 3-4 year period, in comparison to 2 to 3 articles per newspaper in a 10-11 year period. Now, one of the clearest examples of can public opinion shape judicial decision making is this Niyamgiri case. And there is documentary, there's scholarly work on the question whether public opinion shapes judicial decision making. A lot of this comes out of the Western world, and that's clearly out there. Judges have written scholarly papers stating, yes, it does have an effect. And this case, the Niyamgiri case, becomes a prime example of that. Now, one of you had asked this question, whether this is a good thing or not. What does this mean for independence of the judiciary? Well, one, independence of the judiciary is independence from the other organs of the state. When we talk about independence of judiciary, we're talking about independence from the executive and the legislature. Right? Independence of judiciary from the society is something that only a very formalistic positivist would swear by. Anyone who's coming from a critical realist tradition of judicial decision making, of legal thought, will say that there is no such thing as independence of the judicial mind from its society. Right? You would have noticed a lot of these judgments, especially ones with respect to people accused of terrorism-related crimes, the judiciary will give death penalty to satisfy the collective conscience of the nation. What does that mean? That basically means that the judiciary is stating that it is being driven by the public opinion. So that does happen. Whether it's a good or a bad thing, you cannot have a hard and fast single answer fits all situations. In this case, the judicial decision making in the 2013 judgment is definitely shaped by public opinion. However, legally speaking, the 2013 judgment is the correct judgment. The 2007 judgment is absolutely wrong. It has no law in it. It's a shoddy reliance on sustainable development. It's in that form. I thought this was one of the questions that I really wanted to answer in my presentation. That judicial decision making and the idea of independence. Right? It is independence from the other organs of state, the legislature and the executive. Anyhow, so what the Supreme Court states, and I'm now going to wrap up in a couple of minutes, what the Supreme Court states out here is that you need to go back, the state of Odisha needs to go back to the Dongriya Kond people and hold a referendum and get their consent on the project. Right? So this is why also the Niyamgiri case is important. It is the first example of environmental referendum under the Forest Rights Act. And in that referendum, which was held in 13 different Dongriya Kond villages, 10 of them returned with unanimous decisions against allowing Vedanta into their forests, against allowing Vedanta to desecrate their god. In the other three, there were one odd people who said, okay, fine, we are in favor of this project. But by and large, the Dongriya Konds refused consent, which was a requirement under the Forest Rights Act. So this was my presentation on environmental justice or environmentalism of the poor. I hope I've been able to showcase to you the idea, the difference between an omnivore and an ecosystem and the ecosystem people in this thought on environmentalism of the poor. I hope I've been able to showcase to you the preferential treatment that goes in favor of the omnivore against the ecosystem people. And I hope that I've been able to showcase for you how public opinion can sort of shape judicial decision making. Right. So that is it from my side. I'm not taking a lot of questions which were sent across to me because they were either nothing to do with this presentation or I have already covered them in this presentation. So I've answered what environmental justice is. I've connected the story and the idea of environmental justice, environmentalism of the poor to the Constitution of India. I have looked at independence of the judiciary in relation to this present matter. So I think I've answered some of the questions. And the other questions had nothing really to do with what I was presenting. So I am not answering them here in this presentation. But in case any one of you wants to have a conversation about it, my email ID is with your professors and you can sort of ask them for it and write me an email with a specific question and I can try and answer it for you. Anyways, thanks for joining in.
A very good afternoon to all, one and present, respected principal ma'am and all the participants. It is my privilege to have been asked to propose vote of thanks. I, on behalf of the Department of Law and the volunteers, extend a very hearty vote of thanks to the honorable delegates who blessed us with their presence and took out valuable time of their busy schedule. I especially would like to thank Mr. Jakteshwar for his wonderful lecture. He has very minutely discussed the concept of environmental justice and its various aspects and what is the importance of environmental justice in today's scenario. The way he explained the topic is exemplary. I also wish to express my gratitude to our principal ma'am, Dr. Simrat, for the encouragement and support. I also would like to thank Professor Jokinder Paul for giving us an opportunity to conduct this webinar. I heartily congratulate all the participants for their active participation in this event. I would also like to thank Dr. Mehta, the teacher in charge of Department of Law, for his efforts in organizing this event. I also extend big thanks to the organizing committee, Japji, Praful Sharma, Vani Garg, and Harneet Kaur for their hard work and support. Thank you all for making this event successful with your contributions. See you all tomorrow for the second session with another exemplary speaker. Thank you once again. Be safe. Stay at home. Thank you all.